I'm Jon Lentz, City and State's Managing Editor, and this is Last Look. I'm joined today by Joel Shufro, Executive Director of the New York Committee for Occupational Safety and Health. Thanks for joining us today.
Thank you.
And today we're talking about the Scaffold Law. Just the other day we talked to Denise Richardson at the General Contractors Association who wants to reform the law. You're on the other side of this issue. Tell me a little bit about defending it.
Well, the law is a common sense approach to dealing with workers who work in very dangerous situations, workers who work at elevated heights. And it essentially says that employers are responsible if workers are injured, if they fall from heights, if the employer did not follow safety regulations and legal prescriptions. And so it essentially says that in these highly dangerous situations, that employers who essentially control the workplace have the responsibility for following the law. And if they don't follow the law, then they are liable for injuries that occur.
And now this is for any gravity-related injuries, as I understand
That's
it,
correct.
and it's absolute liability. I think that's an issue for opponents of the law, that they don't necessarily, in any case, take into effect what the worker's behavior was.
Well, if the worker is not following the prescriptions of the employer in terms of wearing equipment that is provided to him or her, then the employer is not responsible. If the employee is drunk on the job and can be shown to be drunk on the job, then employers are not responsible. So it is not true that under all circumstances that employers are liable. It is true that if they do not provide workers with equipment, if they provide workers with faulty equipment, then they are liable for the situation.
Now, there was a February 2012 ruling, a Judge Robert Smith. He wrote that the Scaffold Law, quote, imposes liability even on contractors and owners who had nothing to do with the plaintiff's accident. He continues, and where a violation of the statute has caused injury, any fault by the plaintiff contributing to that injury is irrelevant.
It is, the situation is that there are laws that govern the workplace when people are working at heights. These are prescribed by the federal government, by the state government, and so if in fact the worker, if the employer has not complied with those regulations, then they are responsible. And so my sense is that this is a common sense way of dealing with a problem. Employers, for example, will not give workers the right to refuse dangerous work. They want to maintain control. If an employee comes and says, I'm not going to do this because it is in violation of the law, they can be subject to retaliation. And so we're dealing here with a whole range of issues. So let us take, for example, a large number of workers who get killed on the job are Latino immigrant workers, some of whom are documented, some of whom are not documented. They have virtually no control over the situation in which they work. And so an employer will take advantage of that situation. So this law essentially provides them with a strong recourse to an incentive for the employers to follow the law.
Mm-hmm. And one other point that has been made about this is that I believe New York State is the only state that still has this law as is, and opponents are saying, we shouldn't repeal it, we should reform it.
Well, first off, other jurisdictions do have legislation of this nature. I believe that there are about 7 or 8 other states that do have legislation of different types, covering different. Some make it even easier for people to have access to the courts under this situation. our sense is that this has worked. In some states where they have repealed it, Illinois is generally pointed to as having repealed the law and then seen an increase in the number of people who are employed. But what they don't take into account is that employment in the construction trades increased even greater in New York after during that same period, so that there's no necessary correlation between the repeal of the law and job increase.
Though, again, some of the opponents say a big issue here is cost. That you have, because of this law, you have rising insurance costs, projects are much more expensive. The Tappan Zee Bridge, you add tens of millions of dollars to that price tag. And at a time when you want the economy to recover, is there any middle ground? Is there a way to try to reduce those insurance costs?
Yes, the most important way would be for the employers to comply with the law and provide workers with safe and healthy workplaces. Their insurance costs would decline dramatically if they did that. And secondly, I would say that we do not know the way in which the insurance companies operate. They have not opened their books to determine what the actual costs are. We don't know over the long run whether, for example, they have cut insurance rates at a period of time to attract business and bring in customers, and then been forced to raise them because they had cut their rates below market levels. They do not open their books, and so essentially it's a black box that we're looking at, and we're only dealing with assertions from the insurance industry and from employers that the scaffold law costs them money. Finally, I would say is, who actually bears the cost and who should pay when a worker is injured on the job? Who has the liability? Should it fall on the worker and his family, or should it fall on the person, the entity that controls the workplace? Our position is that the employer has that responsibility that is required under federal law. They've maintained their responsibility, and we think that this equitably apportions liability.
And some critics of this law also point to the trial lawyers. They say in these settlements, a big cut goes to trial lawyers. They point to Assembly Speaker Sheldon Silver as defending the status quo here. Is there any concern on your end that that's one incentive to keep this law in place?
Well, there's no question that trial lawyers represent workers. But my sense is that the key here is that this law provides a strong incentive for employers to obey government regulations. If they obeyed the regulations and workers are injured on the job, the lawyers have no business. If they maintain safe workplaces and the number of workers drops dramatically, number of workers who are injured on the job drops dramatically, lawyers are out of business. So, our emphasis here is on making the workplace safe and making sure that workers who go through the rest of their lives injured, unable to protect their families, forced to have their kids withdraw from college, have a recourse to deal with conditions which are in the control of the employer who has responsibility.
Now, I believe there's one piece of legislation up in Albany that would change its absolute liability and say, look, let's go in, let's investigate this, let's determine who actually was at fault. And sometimes it might be the employer entirely, sometimes you might actually look and say, well, the worker was at fault. Are you opposed to that kind of legislation,
yes,
or are you saying it's already like that right now?
We are. When the Occupational Safety and Health Law was passed in Congress in 1970, there was a huge fight over the question of whether workers should have the right to refuse dangerous work. And the employers said, we're not going to give that right to workers, but in exchange, what we will do is we will maintain control of the workforce. We will say that we are responsible. We believe that that's the proper principle. That employers have said are in control of the of their workplace. If workers are building a building improperly, who's at fault? Is it the fault of the worker, or is it the fault of the people who are in control, who are mixing the cement improperly? We think that workers on the job are not in control of the circumstances under which they work, and therefore we do not think that this is a question where apportionment of liability is appropriate.
And you've been paying attention to this issue for years, I'm sure. Do you feel like pressure is increasing? I mean, are you concerned that maybe next year lawmakers may take a serious look at changing this?
Well, I have been working on this issue for a long period of time, and my sense is that the employers feel, as a result of the decline in the labor movement, labor density in this state, from down to 22%, it was up 28% a number of years ago, that they are looking for ways of undercutting protections that workers have. They want to shift the liability from their which they have onto the backs of workers, and they are looking for whatever way that they can do that, and they are coming with increasing intensity to try and shift that liability.
Joel Shufro, thanks for joining us today.
You're welcome. Thank you for inviting me.
And that's it for Last Look. To check out other Last Look videos, go to our website, cityandstateny.com.